Hello, hello.
Hi,
Looks like
everyone.
we are live. I wish there was a way to confirm that we're live. Maybe somebody in the comments could say it's happening. Do you see us? Do you not see us?
I see comments, and hi, guys. So, hey.
Awesome. We are here. Awesome. Cool.
Oh, there we go.
Well,
Okay.
thank you all for joining us. We have two slightly under attorneys, one super busy one. So you're getting as much of us as we can possibly give you today. It's an important day. Yesterday was an important day in the Lively Wayfarer case. Huge order, 152 pages. There were so many important things that came out of that, and we're going to try and get through as much of it as possible. But that's why we are coming together now, despite being, under duress. Just kidding.
Some kind of Sudafed something. So
I just did one of these Afrin sprays to
that's
like,
just addictive, man.
and
Yeah.
I'm like, my mom's like, you're only allowed to do that for 3 days, and I'm like, I don't care.
Oh, by 3 you mean 10, right?
You mean like forever? Because I can't breathe.
I know.
All right.
Uh,
We have to say hi to Frank. Look at Frank.
Frank.
Everyone look at Frank.
Frank decided to come. Frank was very excited to get the order. He was literally looking at me like, why are you I always wonder what he's thinking when I'm talking to my phone.
Yeah.
Like, you know what's going on, but are you tired of hearing me? He's mad at me because he didn't get to go for a walk yesterday because I didn't really have time. So I'll take you for a walk today, okay?
Oh, Frank. I want to hear his analysis. My dog, whenever he hears me on the phone, he thinks it's the right time to ring his little doggy doorbell to be like, attention on me. What are you doing over there talking to your computer? We are all dog moms too. Look at that.
This is true.
Okay, so I want to show you that I printed this thing because that's how psychotic I am, and highlighted it with an old school highlighter millennial style, and even put tabs on this thing because that's the only way I know how to read something like
We
this.
love a tab. We love a tab.
Just gotta love a tab. So despite my beautiful organization of this document, I think the best way to go is to just kind of go through high level, like what has happened. So the high level summary is that 10 out of 13 of Lively's claims have been dismissed. And I've seen a lot of questions about, is it prejudice? Is it without prejudice? And the quick answer is, when it's at a motion for summary judgment stage, there is no with or without prejudice. It's gone, finito, done. The only way that these things could be reviewed, and that's at a very specific review process, is through an appeal. And at an appeal is when people would look at, people meaning the Court of Appeal, would look at whether or not the trial court, Judge Lyman, appropriately used discretion, and that would be the only review of the claims. They don't come back ever again. She cannot bring them back ever again. They're gone.
I will say, though, didn't he say that TAG could potentially renew their motion for summary judgment on the aiding and that's like the one weird thing. I
Yes.
think.
Yeah, and I wanted to ask you guys what you thought about that, because, and maybe I just didn't get to that point because I at page 140 today I had to stop. But what do you make of that? What is that about?
It felt a little bit like, hey, there could be an argument here. If you want to make it, I'll consider it.
Yeah.
There's something here that maybe shouldn't go to a jury, that like, hey, hint, hint, which judges, we all know judges will do sometimes, like, hey, do you want to brief something on that for me so that it's on the record? That's where I was kind of reading that, but also maybe just it wasn't briefed thoroughly enough that he kind of gave them I'll give you a second shot at this now that you know.
I agree with Britt, and my takeaway from it was, and this is just me jumping to conclusions, that TAG would have a decent argument that everything they did as an agent of Wayfarer because they were asked to. And so TAG shouldn't be separately liable. If you're going to find somebody responsible, you can find Wayfarer responsible, and that should do the trick. That's my guess as to what he's telling them, like, hint, hint, you are hired to do this work.
It was definitely a hint that they should file one. I've never trying to think of an example of a time I've seen a judge say, "Hey, if you want to renew your motion here, you should do that." I think if the court is suggesting you should. Although I guess the court did suggest that they could amend their complaints, but that's a totally different analysis. So with the motion for summary judgment, I would be surprised if TAG didn't renew their motion here. Although we don't know everything, so it's possible that there's reasons why they wouldn't. So that's kind of interesting. The individual defendants, so Jamie Heath, Justin Baldoni, Steve Sarowitz, Jen Abel, they've all been cleared of any claims against them. Those claims have been dismissed. There are no individual claims against them. So the only remaining claims are against It Ends With Us Movie LLC, Wayfarer, and TAG. And they're very specific to the claims. So maybe we start with the contract claims. What do you guys think?
And I'm seeing a bunch of comments in the chat about Blake's request for the conference regarding her change of settlement. We'll get to that last, I think, but we will get there.
I'm just now reading that while we're talking.
I don't know what that is because I was busy reading this. What is that? Should we talk about it now?
We could actually start there if you guys want.
Yeah, let's start there.
Yeah.
So it's from the magistrate, right, Britt?
Yeah, let me pull it up. I downloaded it on one of my devices. I could not tell you which one. There it is. And I have that annoying setting on my computer where nothing opens automatically. Why would it? Okay. The
Okay. I see
magistrate
that.
judge, based on Lyman's opinion and order, granting in part and denying in part, and motion for summary judgment on the pleadings, blah, blah, blah. The court orders as follows: a counsel-only telephonic conference with counsel for plaintiff to discuss their client's updated settlement position is scheduled for Monday, April 6, 2026 on the court's conference line. And an updated telephonic conference with counsel for defendants to discuss their client's updated, settlement position. So,
so
do you want me
there's
to send
obviously
this to you?
I got it. So it sounds like there's some update happening behind the scenes. Either the parties submitted updated settlement positions. It's unclear to me from this when that happened. Like, did it happen last night after the order came out? Did it happen before the order came out? We don't actually know. But this suggests to me that there has been some ongoing conversation about settlement. And now that there is an order, naturally, it makes sense for the parties to reapproach, because we have a totally different trial at hand than we did 2 days ago. The parties are looking at a significantly reduced and narrow set of claims. And usually when that happens, lawyers have conversations with their attorney or with their clients to say, this is what's going to cost. This is what it's going to look like. Like, how do you feel about resolving this? And so naturally, those conversations are happening behind the scenes.
Britt and I are repositioning our side.
I was told I was freezing. Not temperature wise.
Yeah, Arizona.
Yeah. So hopefully I'm just sitting right next to my router now. So
Okay.
Hopefully
all right.
That's
Lighting?
better.
No, that's worse.
Nope, that's worse.
Lighting. You guys look okay to me on my end, but we'll monitor the comments in case people can't see or hear you. So please let us know.
I've posted videos on the internet where I'm like right before bed, no makeup on, cried all day. Like, y'all have seen me at my worst. Like, what more can I do?
Yeah.
Yeah,
All the sniffy noses. It's true.
I know. Oh my
We're
God.
trying.
Yeah.
Crying. I was on call right before this and I was talking to somebody and I was like, can you hang on for a second? And I literally like muted myself and like snorted and then got back on the call. So I think the thing that I want people to remember, I think you guys would agree with me, is that yes, technically this is all set for trial. Technically everything is going to trial until it's not. Right? The parties have control over whether it goes to trial or not. So it is on a trial docket. They are treating it as if the remaining claims are going to trial. But these settlement discussions are probably going to kick up a notch here. It sounds like they already have. Because you are now looking at settling a much smaller amount of stuff. Yeah. So it's possible that it will go to trial, but it's not a guarantee. It's never a guarantee because the parties get to decide.
Yeah. And it's also possible that it doesn't settle until trial starts. I had a case once that settled in the middle of a trial. The plaintiff rested and the judge indicated this is not going very well for the plaintiff. And then we all got together outside the courtroom and, and we're like, look, like you're losing this. Right. And it's settled for way less than they would have gotten had it done before trial, but it happened. The case settled right there in the middle of the trial. So anything is possible, and we don't know all the considerations that the parties are taking in, what they're worried about losing, and we could speculate, but it's not really worth the time to do that. We'll know when they settle, when they do. And there's been question over and over again. We've answered, but we'll answer again. Can Lively just drop the remaining claims? No, she can't just drop her claims. She has to get approval from Wayfarer parties. I'm just using Wayfarer generally because it's easier. But she has to get approval from the defendants, consent from them to drop her claims. And that doesn't happen unless there's a settlement. So no, she can't just walk away from this because she feels like it. This is like Nag said, this is going to trial unless the parties settle.
One of the things that I saw today that really made me think was I was just reading the news coverage and there was one, I think it was from like page 6, so who knows, but they were citing some kind of PR person who said, this is a real reputational problem for Blake Lively because, there's plenty of people in Hollywood waiting to take her place. She's not the youngest person in the world. And so it will be easy for the studios to just say, you know what, we'd rather just go ahead and go with somebody else. Hold on, there's someone at my house. Oh, it's the DoorDash guy. Don't worry.
Important.
It's very important because if my teenager is not fed, he will fall apart. But she was talking about how, so I started thinking like, let's just say the best case scenario for her is to get a judgment at a trial that she was retaliated against. I don't know that helps the bigger reputational problem now that the sexual harassment is out.
Yeah, I mean, I think that's the thing. Like, the only claim that really deals with this is the retaliation claim. And as I was reading through the judge's order on it today, I actually understand why he preserved the retaliation claim for the jury. But that is the question, is whether or not what they did harmed her reputation, and that's what she cares most about, is her reputation. So in a sense, that is what the trial has to be about, is her reputation. But I don't know that a trial is going to salvage their reputation for anybody. The irony is I don't know that a trial, and at least from a public perspective, I don't know that a trial will save your reputation.
I mean, even if it went great for her, and everything happened and it just all fell into place, they would appeal it for sure. And so she would have a judgment or a decision by a jury that some people put some stuff on the internet that made her look bad. I just don't know how much, when you're thinking about settling, it's like, what's my best case at trial? What's my worst case at trial? And her worst case seems a lot bigger to me than her best.
Mm-hmm. Yeah. At this point, yeah. And because the sexual harassment claims are now dismissed, her worst day is not very good for her reputation, because her worst day is they didn't do anything to harm your reputation. You harmed your reputation, basically, is what that implies. And that's
Right.
not a very good outcome. That's not a good posture to be in losing.
Can you all hear me better now? I was getting complaints that I sounded bad. Can we hear you?
You sound fine. Yeah.
Okay. I want to remind everyone too, when it comes to retaliation, as far as when you are bringing a motion for summary judgment, you are bringing a motion for summary judgment and carefully picking the evidence that they cannot come back and say, actually, this is debated. So you're not bringing your best evidence, you're bringing the best uncontested evidence. And that's really important, because when you oppose a motion for summary judgment, you're throwing your best evidence out there. This is everything we got. Let this go to trial, right? And so we have not seen Wayfarer's best evidence when it comes to the retaliation, right? The disputes about the expert reports, about the stuff she may have done in the media first. We see some evidence about that, like text messages back and forth. Hey, we're seeing this article. We think they're planting it. What can we do? So all of that would have been disputed fact, and it wouldn't have been given to us yet. So they may still have more that behind the scenes, Blake might be going, I really don't want to try this.
That's a good point. That's a really good point, because they brought the motion for summary judgment. Lively didn't, even though she said she was going to, but she didn't. but they all they had to do was show that, the bare minimum, that the plaintiff can't prove this. They didn't have to necessarily prove that they didn't. And all the court did was said there's a tribal issue of fact. There is a dispute of fact. There's a dispute of credibility. There's a dispute of fact, and a jury is the one that needs to decide that, not me. And that is the standard of a motion for summary judgment. He actually did a really good job showing that it could go either way. And because it can go either way, that's why a jury needs to be the one to decide it. So he didn't actually make a judgment call on whether or not retaliation happened. He specifically ruled that he's not going to do that, because a jury could decide differently based off of the facts presented. And I wanted to highlight, if I can find it, but he says that all she needed to show was a scintilla of evidence, which is like a word we lawyers
love that
word to say.
But
but that's all.
Go ahead. I was going to say, while you're looking for it.
No, go ahead. Go ahead.
He did go out of his way to say, I want to be clear that defending yourself and hiring a PR crisis firm is not retaliation.
Exactly.
He had multiple pages there where he said, I want to be really clear here that, hiring a crisis PR firm is normal. Caring about your reputation is normal. Being defensive is normal. And I think the way he phrased it was, the question here is, at some point, did it stop becoming defensive and start becoming offensive? That's the question he thinks the jury ought to decide.
And he just decided the McSweeney case. He's quoting himself a lot, which is hilarious.
A lot.
But
I love that.
He's basically he's quoting himself in McSweeney and saying he just decided a lot of this. An employer going out and doing public relations is not is not normally retaliation. That it's expected that if you say bad things about your employer, they will respond.
Yeah.
So,
and the other, I think some of the people in the chat were saying it perfectly. If she were to go to trial on these retaliation claims and lose, not only does it disprove the idea that Baldoni and company did it, the fact that there was, in fact, negative publicity is undisputed. And so if it vindicates Wayfarer, that means that everyone really does hate her. That means that there would be a jury verdict that proves the fact that all the dislike for Blake Lively is, in fact, organic. And that is a very, very big downside.
Yeah.
Because that is almost worse than, I tried and lost. That will confirm by its decision. If it wasn't them, it must have just been that people hate her that much.
Well, and her argument has been that they used bots to falsely inflate this narrative around her. But I think you suffer on causation. So even if she could prove that Jed Wallace uses bots, which Jed, says I don't use bots, and the judge kind of goes into like a jury could not believe him. They need more than just we don't believe Jed, but even if she can prove they use bots to inflate this narrative around her, how do you, the causation of there's protected activity and then people online are saying bad things about her and they're inflating that narrative about her. How do we prove that's connected to the protected activity? That's a tough causation to sell to a jury, especially if the jury's like, people already hated her, like they're not okay.
Yeah.
And if they're doing it defensively, I don't think a jury buys it.
Yeah, I mean, the jury's going to have to find that it was that their actions was the substantial motivating factor, because now we're just looking at California retaliation elements,
Yeah.
not Title VII, was the substantial motivating factor for them. And if they come to trial with evidence that shows it wasn't the substantial motivating factor, was to retaliate against her based off of her protected activity, it was actually because we were protecting our reputation.
Yeah.
That's what the jury gets to decide. And that's why this issue is preserved for the jury, because he couldn't make that determination because there was a scintilla of evidence to suggest that. And I did find a quote. It says, the question is whether Lively has provided more than a mere scintilla of evidence. Scintilla is like, how do I define it? Just a hair.
Feathers weight. Yeah.
Yeah.
Like where just the feathers weight on one side, right? Not even 51%, just a 50% of evidence to support her claim, such that a reasonable jury viewing the evidence in her favor could find that the Wayfarer parties took adverse employment action against her because of her protected activities. That was his job at the motion for summary judgment stage. And he did, I think, beautifully outline how there is just a puff of evidence to suggest that it could be. And because there is a puff of evidence that it could be, it goes to the jury to get all the evidence at trial and for the jury to weigh the credibility of all the witnesses that are going to talk about it, weigh the credibility of all the documents, weigh all of the evidence in totality, and make a determination about whether or not they think that Wayfarer parties was motivated substantially to whatever they did. First of all, if they actually did it, and whatever they did because of that protected activity. So
Right.
On the protected activity piece, because I found this particularly frustrating, was that he identified the November 2023 17-point list, the 2023, yeah, 2023 17-point list as one example of protected activity. And I remember, and I went back to my handy notes from March of 2025 when I was first analyzing these claims and thinking, this is outside the statute of limitations. You can't bring a retaliation claim for something that happened more than 300 plus days away. And unfortunately, Wayfarer did not bring an exhaustion of administrative remedies affirmative defense. And the court noted that, or Lively noted that in their papers, and the court said, they didn't argue it, it's waived, it's gone. So that could have been a way that Wayfarer could have gotten rid of this claim on technicality. but
You mean the
they
law?
didn't.
What technicality that was.
I hate that. That frustrates. Can we just talk about this for a second? Technicality is just a charged word that is. I tried to make this distinction on Reddit actually today because I was so frustrated by it. A technicality is just that. You filed this claim one day after the statute of limitations, or you used FedEx when the contract required you to use USPS. Therefore, you lose. That's a technicality. But when you're talking about independent contractor analysis, the judge cited to case law dated 1926. That's 100-year-old case law that was referenced in this order. Like, this is well-established law, federal law, that all the lawyers involved knew about from the beginning, and they tried it anyways. They tried their hand at it, and they lost. So this is not losing on a technicality. This is losing because the well-settled law never was going to allow you to win on that argument. She should have never brought her claims in federal court, frankly.
Well, and the difference too, right? There's a reason we look at independent contractors differently, and that's because you have the ability to change the nature of your employment. Okay, I feel this is a hostile work environment. I work from home now. Try me, right? Or I can walk away. There is no employment contract. I can leave. And the court even notes at one point, you know, had Wayfarer decided to move on and reshoot with a new actress, she still gets her money. She still gets her bag, right? So, like, there's a reason that employees and independent contractors are treated differently, and there's a power differential there that we're talking about. So this technicality is really driving at, she didn't have the power differential that she needs to prove harassment. And that's not exactly the rule, but that's sort of the underlying, that's a piece of the underlying rationale and why we haven't changed this law since 1926 or whatever you just said, right? Like,
one important point that gets missed every time we talk about this, I miss it, and I just want to make sure we don't. They also sued under California law 51.9 that allows for claims of harassment in professional relationships. So business relationships, and they lost that too. So to say that this is just a technicality because she was a contractor, no, I'm sorry, no, because she also lost it as a contractor. So, you know, that just really bothers me because it's so wildly inaccurate.
Well, just to jump off what Britt said with like the power dynamic, the thing that contractors can, the reason contractors aren't covered is because the thing that contractors can do is exactly what she did. Said, I'm not coming back to film unless you do everything I said. And they said, okay. That's what an independent contractor can do.
Yeah,
exactly.
Say, you will change the workplace for me. So, like, the irony to me of that still being the live claim on that 17th list, it's like, that was the independent contractor behavior, right?
Yeah.
Like, it's not.
She's the ultimate. She's the ultimate independent contractor.
Yeah.
You know anybody? I know lots of independent contractors, and I don't know anybody who could pull that shit off.
No way. No way.
Well, and I did notice that the judge also cited, I think it was the email to the decorator or something, where she said, I own this movie.
Mm-hmm.
He also cited the fact that she profited off of how much it made. Like, you can't be an employee and make profits on the back end. Like, that's just...
And, you know, to take that to a jury, there also was ample evidence that she held the power dynamic anyway. And Elle, you've done a really good job of really driving that home of like, the text with Taylor Swift really show that Blake understands that I am the top dog on this set. And so, you know, even if she hadn't have lost on a technicality here, like, she would have lost it. I'm really sorry. I can say that with my full chest, 99% sure she would have lost at trial, because there's just so much evidence of how much power she held.
Her PGA letter was truly a remarkable document. It truly killed this for them. They had that when they filed this claim, which is astounding to me, because I do not know how they thought that they could get around that document, where she lays out every which way, and the court went through painstaking detail of that letter, every point of that PGA letter, to say this is how she's admitted to having control over her employment situation. So
I kind of want to do a deep dive into Gottlieb's other cases, because after looking at Blake and Drake, I'm like, what else is he out there doing? what you doing?
What are you up to, Mikey?
Yeah. Hey,
I did notice, like, I was looking for it with the whole notice and cure issue on the actor loan out agreement, because he found two different grounds for why it's unenforceable. One, she didn't sign it, and two, even if she did, there's a notice and cure provision, and the notice was given by Gottlieb whatever it was, December 20th. But he gave it to It Ends With Us LLC. No, he gave it to Wayfarer and not to It Ends With Us LLC. And I am just dying to know, although I never will, was that on purpose because they were trying to keep something in their pocket about the movie, or did he fuck that up?
Yeah.
And I don't accuse lawyers of malpractice because I don't know what's going on. I think we've covered that ground this week.
Yeah.
But I'm interested to know. I mean, like you said, he had the offer letter. He had he knew that It Ends With Us Movie LLC was the proper party. Why didn't he send the notice to them too? I don't get it. It wouldn't have salvaged it, but it gives them an extra ground, you know?
After reading the thorough analysis of the contract posture in this case, the thing that kept coming to mind for me, and I thought this before too, but especially reading this order, is that they really tried to play both sides of this coin. They really tried to have an agreement, but not have an agreement. And only have an agreement when it benefited them and not have an agreement if it didn't future benefit them. And that is just sort of slippery lawyering, in my opinion.
Yeah.
Like, we're not going to have her sign it, even though it says there that she needs to sign it, but you acted on it. So therefore it's binding to you. It's like, there are rules to this, and everyone knows the rules to this. And so I thought that was really interesting, because even with this notice that he sent to Wayfarer, unless he wasn't the one privy to the contract negotiations, and I don't know that he was, why wouldn't they have checked that? That seems like a really kind of obvious thing, unless they thought that they could just sort of sorry, one more thought is, and I'm sorry I'm a little bit scattered today, but I think that this just indicates to me that they never anticipated it getting this far.
Totally.
Because lawyers always act in anticipation of litigation. Always. That's what we're trained to do. Yeah. We're trained risk-averse people so that we prevent litigation from happening, and everything we do is lined up to prevent that from happening. In this situation, it does not seem to me that that's how they were moving. That Blake's lawyers were moving just to advantage her in the moment that she was in, to get her the best outcome in the moment she was in, whether it be the contract, whether it be the rider. It was like some things set up for potential future claim, but it was not prepared for future litigation at all.
Who prepared the notice?
Gottlieb.
I know you just said
Gottlieb
did.
Yeah.
Okay. Yeah.
I mean, I've grown to, I'm sorry, Britt, you're talking.
No, it just is so interesting because it is common practice for most of us to be like, I don't know, screw it, put Wayfarer on there too. Hell, put Justin Baldoni
all
on
of
there,
them.
Put Jamie Heath
Yeah.
on there, put
Go ahead.
Attorney on there. We're gonna send this to 10 different addresses just to make sure. And I was wondering, like, is that just because I worked for the government and I know there's like really strong, but I feel like that's every attorney's.
That's what you would do. It's better to do it and not need it, right?
Yeah.
I think y'all convinced me. I mean, the royal y'all convinced me that they didn't expect it to go this far. And now I think I kind of see what they thought might happen, which probably sounded really good at the time. This is a weak case, but the public doesn't know that. We'll file this case. We'll get everything dropped in the New York Times. They will file motions to dismiss based on the ALA, because they didn't attach the ALA not being signed, and we've got some problems with independent contractor, whatever. They'll get it dismissed. And then we can say, oh, well, I guess nobody will ever really know because they didn't want to face us in court, and this will hang over their heads forever. And it was kind of a decent plan, except
until somebody called their bluff.
Which is very rare. Like,
Yeah,
that is not how you make the arguments you can, right?
I spent a solid 8 months big mad. Like, why did they not move to dismiss some or all of these claims? What the hell are they doing? And now that we've gone through summary judgment dispositive motion stage, I'm like, oh, that's the smartest thing they could have done. And that comes from Brian Friedman, who has a PR mind, right? Because I would have just been like, procedurally, let's try to dismiss this. But Brian Friedman is saying, you want to clear your name. Let's show them the truth. Let's clear your name.
Yeah.
Can we also talk about another kind of fantastic thing that happened that I overlooked? When their contract claim got dismissed, the court said, "You didn't identify which contract, which provision Lively Reynolds violated. Go back and amend it." And they didn't, because they would have had to attach the ALA or whatever. And because they didn't, the argument of estoppel, which is, we can explain what that is, but that threaded the needle for me on why they may not have amended the contract claim ultimately. And that, ultimately it proves to me that it wasn't malpractice for Friedman not to do it. Because they were a couple of steps ahead. They were playing chess. They knew that this could potentially bite them in the ass if they brought inconsistent positions on the contract issue. Instead, they hedged their bets, and they're like, "We'll argue the contract issue at motion for summary judgment," and they prevailed because of that.
I agree. That was very satisfying to read, because it's like when you're in the room and you have all of these very smart people in the room, they're saying, okay, well, if we do that, then are we taking the position that this thing is enforceable, and is that worth it? And do we want to do that? And like, they're talking it out. It's not like somebody just writes it and then everyone goes, oops, like that's not a case like this with this many people charging this much an hour. No.
What are we at 15, 20 each side? Like, there are so many brilliant minds looking at this. They're looking at it from different angles that we're sitting here like from our couches trying to figure it out.
Right.
As 3 minds, there is like 36 minds that are planning all of this. And so there's stuff that we just don't see. And we also don't have all the evidence. So brilliant. Honestly, I think it was brilliant that they didn't end up amending that.
I'm actually really impressed with the way things played out. There was a lot of strategy there that, and I knew we're only seeing the tip of the iceberg. We're not seeing the client conversations and the attorney conversations and the work product. We talked about that along the way, but now that we're sitting here, I'm just so impressed with the things I didn't notice. Like you just said, with the contract not being repled, because now we do get estoppel because we're trying to enforce the ALA. Do we want to say that's enforceable and just waive that argument that it isn't?
Yeah.
At the time, we were all like trying to figure out what was up with the ALA, because she filed a complaint, an amended complaint, and a second amended complaint and never attached that thing. And y'all, it is like not even law school. It is like paralegal school day one, that when you are suing for breach of a contract, you attach the contract, because it is the easiest motion to dismiss in the world to say, you have to show us that, right? So the fact that they didn't do it got more and more suspicious over time. And then by the time she got to the second amended complaint and she still didn't attach it, then it was like, this is on purpose. And that was right around the time that Wayfarer also chose not to replead. So I think at that point they were like, you know what? We'd rather preserve the argument to get hers thrown out than to try to pursue our own. So forget it.
Yeah. It was smart move, and it worked out in their favor. Certainly. It was also interesting to see how he ruled that there was consideration for the CRA. I think that was maybe thin.
Yeah, I didn't love it. I was like, ooh, I don't know. But
I mean, but I get it. Like, if you just look at the black letter of what was agreed, she agreed to 6 weeks of consecutive filming, and now she's agreeing to do more. And if you apply this standard to other contract situations, you would hope a court does that, to say, this is what we agreed on. Why are you giving it? It logically makes sense for us. Like, obviously, she has to finish the movie. Like, but the contract didn't say you have to finish the movie. The contract said 6 consecutive weeks of filming. So,
and I'll
it was
be the first to say I was wrong about that. I straight up said there is no consideration. So that's on me. I led you guys astray on that. I was like, there's no consideration here. I don't know how they get past that.
I was with you. And then I'm reading it and I'm like, 6 weeks. I was like, fuck, I think he's right. Damn it. Yeah. This is why he gets paid the big bucks and we don't.
That's why he's the judge, the federal judge.
Now I have other issues with that document that we can talk about when we get there, because I don't know how one litigates the definition of retaliation that is in that document. understand that. But we can get to that when we get to that.
Well, that then Sarah Yarn and Order and I talked about that a lot, where it's not retaliation under the law, it's retaliation under the contract, right? So it's a breach of contract claim, right? Because you don't get to change the law through a contract, but you do get to create your own little world of rules within a contract, within the parameters of what the law allows you to contract to do, right? So, I don't get to say, here's what intentional infliction of emotional distress is, and it's any time you look at me wrong,
Right.
and then sue under intentional infliction of emotional distress, right?
Right.
You sue under the contract. But
that contract, I mean, one of the things that they define as retaliation is sarcasm.
No, yeah. And that's
right.
So
like
that example,
like there has to be emotion in limiting or some kind of jury instruction issue of like, Your Honor, we can't possibly let a jury find that a contract was breached because somebody was sarcastic. Like that.
Right. And it's a vague term. Who decides? What are the parameters? Is there any notice of, hey, you're looking at me wrong, right? Like, you're being sarcastic. What are the rules of sarcasm?
It's literally like suing your school teacher and being like, well, we entered into a contract that you wouldn't be mean to me.
Yeah.
And you were mean to me. Like, this is the issue that's going before a jury. They're not they're not deciding that particular vein or that definition of retaliation under the law on the contract claim. They're deciding whether or not the contract was violated. And the contract defines this term and like essentially saying like he was mean to me. So that's what the jury is deciding.
Yeah.
Was he mean to her?
I don't know why they didn't make that argument in summary judgment. I guess they probably ran out of room. But I was playing in my mind this morning, like, what could they file to challenge that again? Is there some kind of pretrial way they could say, like, how do you come up with a jury instruction for that?
Yeah, that's going to be really tough. I don't know.
We got way off because we were just answering. We go in order so people at least know that we've covered everything. Like,
yes,
you always do in the beginning.
Yes. So I will just recap. We are going in order in the sense that the judge first looked at the contracts. He first ruled that the ALA, the actor loan out agreement, that was the long form agreement that came after the offer letter, that was never executed. The parties never mutually assented to the agreement. So the court found that it's unenforceable. So that actor loan out agreement on all the provisions that came under it are not enforceable. And any reference to it, the court says, I don't care. It's not enforceable. It's not a contract between the parties. He then looked at the contract writer, or is it contract writer agreement that came with came after that 17-point list document that laid out all the conditions in which Lively would return to the set on phase 2 of the filming. And so that one, he says there was consideration for that contract because she essentially agreed to come back, despite the fact that her offer letter said she'd only have to work for 6 consecutive weeks, and this writer's strike extended that. There was enough consideration there. The parties agreed to it, and there was a signature there. And he specifically rules that it doesn't matter that the ALA is unenforceable because you can still look to the offer letter, which is also enforceable, and the parties agreed to that. So that's kind of where we are with the CRA. Was there something that you wanted to say about the CRA that you held off on?
I'm looking through my notes.
I do want to say that, I mean, I don't know if any entertainment lawyers are here, but I wrote a little note to myself on the margin that they are going to firm up these agreements so bad. They are not going to let production continue on a set if it's not signed. Like this is going to have some ripple effect in the entertainment industry, because can you imagine going through this headache as a studio? I can imagine that entertainment lawyers everywhere are going to be like, we will not proceed. We will not let our client proceed until this thing is executed and the provisions. I mean, it is wild to me that we were negotiating the terms of the ALA well after everything was done. Like,
we're done now.
Just
You signed this?
crazy. It's like you built a custom house. It's all done. You've moved in. You've broken a couple of windows, and now you're like, well, you're gonna need to put the window there. It's like, what are we talking about? This is insane. Like,
I was
so
thinking something very similar about PR too, where the judge kind of went through the documents between Tag and Wayfarer that was discussing, you know, we can bury her, and you know, that kind of some of the language in the offer, not the contract, right, of what the services Tag offers. And I was like, I would imagine this is going to change the contracts for crisis PR as well, because
for
that's the
sure,
kind of stuff you're going to not want to put in writing anymore.
Yeah.
for
If we're
sure.
going to say this can be retaliation, that's
I mean, as you're reading through all the stuff, it's like, oh God, I wish they wouldn't have said that. Oh God, I wish they wouldn't have said that in writing if that had all been on the phone. The one
Mhm.
thing that I did want to note on the contracts is that the judge noted an argument that little girl and I heard in New York at the hearing, which was that that the ALA was pretty much it. Everyone recognized the ALA as being in place because Lively got paid extra compensation and bonuses that were not
Mhm.
in the offer letter. They were in the ALA. And the way that the judge said it was basically, if they want to be extra nice and give you the money before you finish negotiating, that doesn't create a contract. I mean, he said a party can provide a more generous benefit thinking an agreement will be. In other words, like, I'm not going to punish them for being generous and giving you the money, even though there was no contract. So I'm sure that's pretty validating to Heath in particular of like, did I fuck this whole thing up by trying to give her the money that she was owed? No, it didn't.
Yeah. Yeah, and I did like that the judge referenced that email in totality and even said to Gottlieb's declaration, this is misleading how you're putting this. It expressly says that Heath says the issues with those provisions, we'll deal with those later. Like we're signing this to move on with our edit, to have time with the edit, but we don't agree with those other provisions. And like so the judge pulled that out, which I thought was really, really interesting. There were a few references to the hearing that I was like, we were there.
I know, me too. I was like,
We heard
I
that.
asked that. I remember that. I think too, you guys tell me what you think, but there were certain sections where it was like when he talked about the waiver of the conditions precedent and all of that. He only has to have like one ground, right? Like if Wayfarer makes 4 arguments for summary judgment, he finds that one argument has merit, he doesn't have to address the other 3. And there were things he didn't address. But he did include more than he had to, and I think that's to shore this thing up in case she does appeal.
Yep.
Do you agree?
Oh yeah. Oh
Okay.
yeah. This 152-page order. The reason why it took so long and why it's so long is that he was leaving no stone unturned for potential appeal. There's nothing here that I've read that the other side can be like, he decided this was wrong. He went through extensive. I mean, I cannot believe I read an AB5 Dynamics analysis in a New York federal case. It was taking me back to 2020 when I was doing webinars on AB5 and the exceptions and blah, blah, blah. Thorough, detailed, factor by factor analysis, and that's because there should be nothing. He left nothing for a court of appeal to be like, oh well, he didn't use his discretion correctly because he didn't, consider 5 of the 7 factors. No, he considered all of them. Every alternative argument for everything he went through in detail. I mean, just the fact that the independent contractor analysis section goes from page 53 to 85, 87.
Wow.
yeah.
Like, it is thorough. There is no breaking that analysis because that is the basis for why the federal claims go away. And there's no question that he decided that correctly. So that I cannot see any grounds for appeal on that.
And I hope the people who are skeptical of the judge now see, like, it's his job to say, like, okay, if you guys want, Wayfarer decided to do discovery. All right, then then she's going to get all this stuff. And then he ultimately gets to make the decision about what it means. Now, I know that people have their own feelings about the judiciary, and I'm not trying to take that away from anybody. It's crazy out there. It is.
I'm sometimes one of those people. So.
Me too. Sometimes I'm like, same. But I hope that people can see now that there's a difference between allowing someone to do discovery and handing somebody the case. For all we know, he clocked on day 2. God, I hope somebody asked me to throw half this shit out. Right? Like, I mean, you just don't know. But I hope people can see like how thorough and careful he was once the arguments were presented to him that allowed him to actually do something.
Yeah.
And it's very difficult most of the time to convince a judge to throw out this much on summary judgment. You really have to have an airtight look. Here are all the things we agree on, or that you can't reasonably argue against.
Right.
And that means that there is no claim to go to a jury, and it needs dismissal now because we've gone through all the evidence and this is the best they've got, and it's not enough under the law. Right? There's no genuine dispute of material fact over this evidence, and that's so hard to do because that scintilla of evidence is enough for a judge to go, I don't know. There's a disagreement over what this clause means. Kick it to a jury.
Yeah.
So
no, I think he did a really careful, thorough job with that to make sure that what does go to the jury. Because at first I was like, how could he kick the contract claim to the jury? Because they did ask for that. I remember Gottlieb said, this is a jury question. This is a jury question. It's like, what? No way. You can't have a jury be deciding these like complex contract like legal issues. And they're not factual issues, they're legal issues. And so he was very careful about threading that needle in this order. Okay, so the next thing is the decision about her status as an employee or not. So we kind of talked about that, but just to recap. So under federal law, long established law, independent contractors are not entitled to the protections of Title VII. That doesn't mean that they're not entitled to any protection at all. They're just not entitled to federal protections under Title VII. So that's sexual harassment and retaliation. Those claims go away if you are considered an independent contractor. The same analysis applies under California Labor Code Section 1102.5. And so the court went through an analysis of both the federal factors and the state factors about whether or not Lively was an independent contractor or not. So that's, I mean, we can go through any questions about that, but that's basically what he decided in 30 some pages.
That, that was the way they teed up the control issue, right? To Britt's point earlier, like that's the way they teed up, did she have control over this workplace? Because that's literally the test under federal law is how much control does the person have? But that control was baked into these claims from the beginning, because how can you alter the terms and conditions of somebody's job if you don't have control over them? And so I just hope that the thing that people take away from all of this is no matter what all discrimination laws in particular are about the balance of power. The reason they were instituted is because the groups of people that they protect had no power. Right. It was giving them the power to be able to speak back and speak out against things that were wrong. So for people to act like, oh, it doesn't matter how much power the person had, it absolutely does for a lot of reasons, not the least of which is this issue. But it mattered all along. And yes, you can say you can still be rich and powerful and all that and be the lead actress and still get harassed. Sure. But to act as if your say about where the job is and what time you show up and who's there and it doesn't matter, that's ridiculous. That's ridiculous.
Yeah. And it's absolutely not true. I've seen some videos about this, but it's absolutely not true that this just sets bad precedents, that even independent contractors are allowed to be harassed. No. This is well-settled law. This has been the law for ages, 100 years. It's not new. This is not new law. And some of the cases, 30 years old, 40 years old, 20 years old, like we're not talking about something that this case is creating. There's no new law. being created by this. If anything, it's reinforcing what Nag just said, that the law was designed to protect the historically powerless in a situation where they are being controlled and their livelihood is being controlled by the powerful, the ones with the pocketbooks. Now, it is true that there are rich people that are employees of employers. But in that situation, those rich people that are employed by employers are still powerless and deserve the protection of the federal laws. And that's what Title VII is for. And so this is upholding that same exact standard that should be applied across the board for everyone, that Title VII is designed to protect the people in situations that they might not be able to do anything in because they're relying on that employment. And here, the court is saying she was not relying on this employment, not because of her wealth, not because of her fame, but because she had power to go get another job if she wanted to. Let's say she got paid $50 for this job. She could go get 5 more that paid her 100 more. That's the point. And it doesn't matter how powerful or rich she was. The law is there to protect you in a situation where you are tied to one person, beholden to them, almost like a servant. And it's to protect the people that historically have been servants in this kind of power dynamic. So it was absolutely decided correctly along the lines of every case that's ever come before it. There's nothing new. It's not precedent, and I will not tolerate that because I've been banging my head about this from the beginning of this case, and I cannot stand people saying that this is a technicality because it's not.
Well,
Also, go
keeping
ahead,
in
Rick.
mind the
Go.
rise in independent contractors in the workplace is exponential, right? And just keeping that in mind, right? If you are an independent contractor, but you don't have a skill where you can contract out to anyone anywhere, you know, just keeping in mind this is one of the limitations of that arrangement, right? Knowing clear eyes, full heart, like this is what you're entering into. You get some tax benefits, but also if you economically don't have the ability to walk away from something like that, the law isn't as protective of you in that scenario because the law is going to presume you do have the ability to walk away. So I do want to recognize, you know, there are people who can't just walk away. I think that's a really privileged thing to say, you know, but that is how the law views you. And so just, I think that's an important thing for people to know, because if you're negotiating an employment relationship, that might be something you take into consideration.
But that's how the federal law views you. California extends these privileges to independent contractors. So that's something that keeps getting missed too, is that just because you're an independent contractor, at least in California, you still have those rights. The legislature has extended those rights.
Care about employees. So that's where
that's what I was going to say is, you know, if nothing else, I hope that people learned the federal laws in America are terrible for employees. They're incredibly employer friendly. We get no paid time off. We get no maternity leave. Everything is geared towards the employers. Like it is not great. And if you don't like that at the federal level, then that is a voting issue, right? But you know, if you didn't know before, you know now that if you are an employee, U.S. federal law is not on your side.
Yeah.
At all.
And a lot of states are basing their employment laws, hi Arizona, on the federal law. We had the federal minimum wage for a really long time. Yeah.
Yeah.
So.
Yeah. Okay.
Should we address this? I'm just seeing the question over and over again about 47.1 really quickly because I'll forget to answer it. It has not been decided. It is still pending before the court. That is something that the court still has to rule on and will rule on. I don't know when, but they will. Maybe he's hoping and praying the parties settle so he doesn't have to rule on it. But this could, you know, impact how the parties view their success on that, given that the harassment claims have not now gone away. It seems less relevant, but it's a different analysis. And so, and again, we've said this before, but this would be an issue of first impression because no other court has ever ruled on 47.1 ever. to my knowledge. And you don't want a federal judge in New York to do it, being the first one. He doesn't want to be the first one. So TBD on that one, frankly.
Yeah, and I guess that one is about her allegedly complaining about. That one's about her main basis for that is Wayfarer suing her, right?
Yeah.
I got to think about how that all fall, because she still has a retaliation claim alive. So she technically still has like protected activity potential.
Right.
But she's saying it was wrong of them to sue her for defamation for making sexual harassment complaints. But because the case is not kind of complete for an appeal clock to run, I don't think that that's ripe for him to rule on it at this point, right?
Yeah.
Like we have to get to the end of the case before he rules on that one. So now that I'm saying it out loud, I don't think we'll get that before trial.
I
Right.
don't know.
Because he's dismissed the sexual harassment, but also said she reasonably believes she was sexually harassed and turned it in, and maybe they retaliated against her. So
Yeah.
Mm-hmm.
I don't know. I think I tend to agree that he's sort of like letting it lie and hoping that he doesn't have to deal with it.
Yeah, that's what I would do.
I wouldn't want to if I was him.
And
I mean,
even
he's
if
in
he
New
were to
York, like,
find,
this has nothing to do with me. I'd like to be excluded from this narrative.
from this narrative. And even if he did, if he were to give her that somehow, they'd appeal that shit all the way up to the California Supreme Court.
Oh yeah, that issue will not die.
No. So I just don't think that's a great idea.
Yeah, it might be something that Lively will leverage in a settlement and say, look, you're likely to lose this, so you should settle with us. I don't know. I'm very curious, what are the things that they're exchanging, the parties are exchanging as the leverage. You always go into a settlement conversation, and Britt, you're the one that's most recently done this, but you always go into a settlement conversation with what leverage do the parties have against each other, and that's when you pull those levers. So this could be a lever that Lively will hold to say, like, it's still pending, you could still get a bad order from us, so maybe it's better if you settle with us. So I don't know, we'll see.
But also I think there's some real risk of, if you're Blake Lively and you're thinking, okay, let's push that really far, let's win. Let's say she wins, okay? And let's say she gets a judgment from Lyman and she has a great couple of news cycles about how she had the first case on this big thing. And then it goes up on appeal and it gets overturned because the law is not, remember, no one's ever looked at it before, because it's unconstitutionally vague or broad or dips into free speech or whatever. She could also be the one who ruins that law for everybody else.
Yeah.
Because when you send something up on appeal, you're going to get a decision that everyone else has to use, whether you like it or not. That is a risk to me, because that thing is
bad law.
Yeah.
Mm-hmm.
Yeah. Yeah. And then it's like, oh, there used to be this law that would protect people, but now there isn't one because Blake Lively put it out there on blast and the judges said no. So I don't know. I think I realize that she's not probably thinking that far away, but everything comes with risks.
Mm-hmm. Yep, including trial. Okay,
Yeah.
so we have the independent contractor issue. We talked about how he went through it in detail. There is nothing I think he got wrong on that. In fact, I thought it was super interesting. He even went through the B2B exception, the business-to-business exception of AB5, which is like one of those situations where you're like, you're exempted from this 3-part test if you satisfy this 12-part test. And if you satisfy the 12-part test, then we'll give you the 13-part test. That's how it literally works. So I was just impressed that he like played that all out, and I was like, man, I wish I had this case like in 2020 when I was trying to explain this to clients. But here we are. Now I have it. But anyway, so that's that, and that's why those federal claims and the Section 11.2 California Labor Code claim went away, because you do not have entitlement to those claims if you're not an employee. Then he went into extraterritoriality, and I say that word slowly because I will mess up the word if I say it any faster than that. So
Relatable.
this is where he went into, I would say, a pretty complicated analysis of whether or not which state law applies and state law applies. And essentially he's ruled that under FIHA, so I'm going to try and simplify this, and please, you guys, if I'm oversimplifying it, correct me. But essentially, by looking at the case law, he's determined that, first of all, California presumes that its laws don't extend to other places.
Right.
There's a presumption that the laws are only supposed to protect activities that happen within its state. And it's possible that things happen within his state, but have an impact to someone that's farther away. So there's the case about the person in Washington, and there's the case about the person in Colorado. And the real question mark is, where did those acts occur? So he did a kind of really thorough analysis of where Lively alleged the acts to have occurred, and went through pretty much all of those specific allegations. Let's see. And he specifically, I just want to make a point of this because some people have talked about this in comments. He specifically avoided addressing whether or not parties can contract around this, because there was a reference to the ALA. Well, in the ALA, the choice of law provision says blah, blah, blah. He's like, I'm not deciding that because the ALA is unenforceable here. So I'm not even going to go into that. Instead, he goes through a thorough analysis of whether or not the state laws apply outside of the state.
I'm trying not to sneeze.
Right.
You're allowed to sneeze.
I know, but I'm trying not to. I mean, y'all, you can go down the rabbit hole with contract stuff. Like, can you use the choice of law? What law do you use to decide the choice of law of a contract if you're not sure about the like I had a case once that went all the way up to a state Supreme Court on, can you get attorney's fees under an attorney's fees clause in a contract if you got a finding in the trial court that you were fraudulently induced to enter into that contract? Because then is that contract, like, you can just go around. Yeah, it was a hoot. You can just go around and around and around and around. And I agree that he was like, I'm not going there.
I don't know what I did, but I somehow, can you guys see this?
Oh, yeah.
I somehow got this.
Does the judge alone make the analysis and write the documents, or most judges rely on clerks for analysis on sections and writing the draft and judge finalizes? I have seen both. I clerked for the bankruptcy judge while I was in school, and her clerk they kind of split cases up. So the clerk would be like, oh, I've got this one, or I did a ton of research on this. I'll take the first crack. And then there were some cases where the judge was like, I got this, I'll do this. So I've seen a little bit of both. In both cases, the judge always goes through. In my experience with the one judge and with the judges that I know, just as personal friends or whatever, yeah, they will finalize the draft of what they receive. They will read all the case law because they're the ones on the bench talking about it, right? So if their clerk does it, they're still going to know the insides and outs, and they're going to make changes, and they're going to finalize. So
it depends on the judge. So I clerked for two judges in California, one at the Court of Appeal and one at the California Supreme Court Chief Justice. And the California Supreme Court does it a little bit. The California Supreme Court does it a little bit in a very specific way, because that court has a goal of a unanimous opinion, which is not common to other courts. And so because the court has a desire to have unanimous opinions, their whole process for getting an order requires, circulating around all the chambers, and it's a whole thing. But so trial court is sort of different. It also depends on how many clerks the judge has. So if the judge has like a panel of sophisticated clerks, they might take a first crack at all the research and putting together everything for the court to look at. Some judges are way more hands-on in cases than others, and they might want to do it first. It really, really depends on the judge. But I would venture to say that it is a huge collaboration between the clerks and the judge. There's almost no scenario that I'm aware of, even like US Supreme Court, from what I understand, where the judge just writes it completely on their own. They work very, very closely with these very, very smart people that work as their clerks. So it is a team effort.
Justice Thomas has a few arbitration opinions that are 3 lines. I'm pretty sure he wrote those on his own, but and that actually is the area of law where I tend to agree with Thomas. And I'm always just, when he's like, "Nah, I'm not into this," like that's essentially the opinion.
No.
You're like, great.
No.
I think he wrote that.
I think
Katie's asking what happened to the amicus people. We don't know. TBD. Those get decided along with the 47.1 motion, whether or not he's going to consider them or not. So I think same answer is about the 47.1, kicking that can down the road.
Yeah. And realistically, you know, he's seen everything we've seen. So he may be looking at this and going, "Are you guys sure you don't want to settle this? Because this is a terrible case to try."
Well, and I think like most of the questions I've gotten this morning, I'm guessing you guys have too, are people who are like, well, what's admissible now and what's not admissible? We can do that after we've gone through all the claims, but like that is far from obvious. Like that in and of itself will be very hard fought about what can be admitted about the protected activity and the sexual harassment and the blah, 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 blah. So like, it's not like, oh, we're ready. We know exactly what we'll make an exhibit list. We'll go to trial tomorrow. Like there are still major fights between now and trial if they were going to have them.
And there will be what's called motions in limine, which is, hey, court, we are asking you to exclude categorically either this piece of evidence or this category of evidence, right, based on the rules of evidence. And I will be insufferable when that happens because the rules of evidence are my favorite thing about practice. So be prepared sometime between the 10th and the 18th to be sick of me. But so that will also cull down what can be introduced. That will really shape what's coming into trial as well. So we really don't know. You know, there's the general admissibility of things under the rules of evidence that we can talk about, but the court will give us a rule around that here soon as well.
Yeah, for one thing, there's not going to be 1,000 pages by Lively anymore. So she will be calling that way down. Sorry, Nat, go ahead.
No, it's okay. I was sneezing. I was just trying to make notes as I was reading through about like what motions in limine I'm thinking there will be. There will definitely be one about Van Zandt. You know, can they exclude all those documents because they were stolen? I don't know. That one's dicey, but I think they'll try. There'll be some kind of motion in limine about lost profits, being too speculative with Blake Brown and all that. I think I told people a while ago that the trial that my husband had last year was a trial where they had a motion in limine. They said the lost profits were too speculative. So the entire trial was like for damages of basically zero because the judge made a pre-trial ruling that the profits that they wanted to get were too speculative to recover. So while not it was great. It was great. He was so happy. And they had a terrible forensic accountant. And he's like, and then she sat in the back of the courtroom the whole time. And I was like, lady, what are you doing? But sometimes you can kneecap a case through motions in limine, even though it's not judgment. It makes your case so shitty that you don't want to try it. Right?
Or that's the piece of evidence that I really need to feel like I can prove X. So now that I can't bring it, should I settle? I had a case where they dumped a bunch of documents on us after discovery. We moved to exclude it, and the judge was like, yeah, you can exclude that. And in there was their slam dunk piece of evidence. So they contacted us and said, hey, instead of going to trial, you want to settle?
Yeah, these are going to be hotly contested. I mean, we're going to get one that has to do with the sexual harassment, anything that has to do with the sexual harassment allegations is going to be hotly contested because while some of it is related to the retaliation claim, a lot of it is not. So a lot of the evidence that they were going to bring in to prove their sexual harassment has nothing to do with the retaliation or the contract claim or the other claim against Tag. So that stuff is likely Wayfarer is going to say, you can't bring any of this stuff because it's going to unfairly prejudice the jury. You don't want the jury to be hearing things about how they were allegedly terrible people and did all these horrible things, like no birthing video, no dance video, no voice note, no tech, all of that stuff that she would have brought to prove her hostile work environment claim, Jenny Slate's testimony, whatever, that all goes away. Or they're going to ask for it to all go away because they're going to say it's not fair. The jury's not going to be able to distinguish what that is for and make a unfair assumption about it. Similarly, I could see Lively's side saying, well, then no Taylor Swift text messages, or then no this. So they're going to think of all of the most damning evidence that they don't want a jury to see and make an argument for why the jury shouldn't see it, because A, it's not relevant to the remaining claims or defenses, and B, it could prejudice the jury unfairly. And so this idea of prejudicing a jury unfairly is kind of a weird conceptual thing, and it's not just like it's gonna like
That'll make
help
their
the other
case.
side. Yeah.
Yeah.
Obviously, like, you're entitled to bring evidence that support your claims and defenses, but there's like a fine line where it crosses over to like it's not actually proving your claim or defense, and you're only using it because it's going to color someone's perception of the other side. And if it's only doing that, then it's a balancing test, right?
The prejudicial effect must substantially outweigh any probative value. Meaning, if there's just
I was trying to avoid saying that, Britt. Trying to avoid the legalese.
Always standards.
It has to be so inflammatory, right? And maybe somewhere within a text message, somebody is saying, I recognize that something happened, but in there they're dropping slurs. You would say the prejudicial effect of showing the jury these slurs or whatever, these, sexist text messages is so prejudicial, and the jury's going to decide against them based on that and not on the underlying thing of what they're saying. Something like that, right? It has to be so substantial in comparison to how it actually speaks to the elements in the case. Yeah.
Mm-hmm. Exactly.
And there's no way.
Somebody said Lyman ruled California law does not apply. I want to be really clear. He said California law does not apply to the sexual harassment on the workplace, on the set, right? Because the set was not in California. It didn't happen in California, but he did say California law applies to the retaliatory behavior, the alleged retaliatory behavior. So just so we're clear, he didn't blanket say no California law. Right. So when we're talking about 47.1, he's going to do a similar analysis where he's going to say, where were these decisions made? Where these actors live? And both Heath and Baldoni live in California. So I don't think he'll bar based on that, but I don't know.
I mean, I had this thought last night where I was like, what if Wayfarer just said, we'll stipulate to the fact that there was protected activity. We don't need to bring in evidence of we'll stipulate to that, which is stipulating to an entire element. Like, I don't know that Lively would do it, but if it's like, part of me thinks that some of that sexual harassment evidence might actually help Wayfarer, because, tell me if I'm getting this right, little girl attorney, because this California standard for retaliation is very new to me. Mm-hmm. So having been used to Title VII, where you have to show that there was a causal link between the protected activity and the adverse action, and you have temporal proximity and all that crap. In California, it sounds like the question is, did they have retaliatory intent? Which means that the mindset of Justin Baldoni and Jamie Heath will be front and center in that claim, which means their credibility versus her credibility is like the whole case. Mm-hmm. Right? So, I don't know. It might not be the worst thing in the world to be like, can you believe she thought this was sexual harassment? I don't know.
Yeah, I mean, I don't think they so much as agreed, but the court kind of references that Wayfarer doesn't really contest that hard about the protected activity. They just say it's too attenuated. They're saying that it happened too long ago. And how can these two things be connected? Like, how can her 17-point list from 2023 or her antics at the premiere, how can those be connected to this allegation that they instituted a smear campaign in August after the premiere, and that, you know, when Friedman was hired, he continued that smear campaign? That was the argument that they presented, and the court noted that. But the court is saying, like, unlike federal retaliation law that is a but-for causation, California has this kind of annoying, difficult standard, which is it's not just but-for, it has to be a substantial motivating factor. So whereas in federal law, it has to be because of the protected activity that the action was retaliatory, in California, it just has to be the major factor in it. And so that's where it's almost impossible to win a summary judgment in California on a retaliation claim, because how can you have no dispute of fact? So what's going to happen at trial is for Wayfarer parties to come up and say, it wasn't a substantial motivating factor. The real motivating factor was we were preserving our reputations. That's what was motivating us. We don't care that she already made her allegations when she did. We're not even thinking about that anymore. We're worried about today. That's why we hired crisis people. We're concerned about today. And ultimately, the jury is the one that gets to sit there and weigh the credibility of the witnesses. They're going to have to decide, was it really a substantial motivating factor for them that, like, she made these complaints back in 2023, so they waited until August 2024 to institute this campaign against her? Or was it because they were trying to protect their own asses? So reputationally. So that's why the court couldn't make a decision on this, because it really does come down to a factual dispute, and why a summary judgment often doesn't get granted in those scenarios, and why the jury is going to have to be the one to decide it. So we're going to see a lot of testimony from people that were involved in this that said, like, you know, I could imagine them bringing some of the content creators that say, like, nobody told me to do this. Yeah. I did this because I wanted to. Or they're going to bring experts that say, and that's another thing we didn't discuss yet, but there's going to be experts that say, like, it's impossible that all these people had a negative view of Lively after whatever happened, that this had to have been because of a coordinated campaign. And then you'll have Judd Wallace go on the stand and say, well, I didn't do that. All I did was look at things. All I did was monitor and report back. And yes, there's all these text messages that don't look very good between Nathan and Abel, and I want to make a point of this, because since we're here, something that came to mind to me as I was reading this is I got the sense that these PR people, having their own little discussions amongst themselves, probably have done this a million times in other scenarios. PR is probably PR'd a million times before this and have sent similar text messages. And you can tell that they were taking credit in front of their client for things that happened in their client's favor. Like, that was all us. Like, you know,
look
Chelsea
at how
Flott made a
good
video.
The internet is
that was
doing.
all us. Yeah. Like, what? Wait, what? How can you take credit? Like, it's almost like some PR person somewhere on Wayfarer's side claiming to their client, to Wayfarer, that us making our content is all they're doing. That they came and liked all our posts, or they gave us our followers, right? That's essentially what was happening, is the PR people are saying, we did this, like, we're taking credit, but there's no actual evidence as of now that we've seen that proves that they bought the followers, that there's bots, that they planted stories. So all of that stuff is evidence that needs to come in at trial, and stuff that the jury is going to have to look at.
Puffery.
Exactly.
That's another motion in limine I bet we get, is the Rebel Wilson stuff.
Oh, yeah.
Oh,
We're not going to want any of that stuff about Rebel Wilson coming in. And I think that should be granted.
It seems pretty well within 404.
Yeah.
I think so. But I think that if I was the Lively side, I'd want that, because that voicemail or that voice message from Jed is not great. My worry about Jed is none of us have ever actually seen this man testify. I have read his deposition. He looks pretty fucking squirrely. I don't know. I think that Baldoni and Heath will come off as good witnesses. I've seen both of those people speak.
Yeah.
And I think Jen Abel will probably come off as a believable person. But Wallace, I don't know. I don't know.
Yeah, I don't know. We don't know how he's
A
going to even
chronically
appear.
online man. So I have an image of him that's probably incredibly unfair, but I have it anyway.
And accurate, Britt. It's probably. And also, by the way, like when we were having that conversation about the sexual harassment stuff, because the judge went out of his way to say, oh, by the way, I just want to make clear that there are some things that could not possibly be sexual harassment. Those things are not coming in even for protected activity. That's the circumcision comment, the dance video, the weight comment by the trainer.
The birthing video.
Yeah, like those things are not coming in because he said in his order, these could not be sexual harassment, at least not on their own. They'd have to be all together. And now that sexual harassment is out, those are out. So I think the universe of what they could try to bring in is even smaller. I think if they tried to use that birthing video and they tried to show a part of that birthing video, I think that would backfire something.
Big time.
Big time. Yeah.
You get 3 women on that jury and they'll be like, are you kidding that this is what you're asking?
Yeah.
Like, yeah. Mm-mm.
If anything, they're lucky that that claim is gone because that would have been really damning, I think, for Lively.
I hate
even
that
just
happens.
the pursuit of it was offensive.
Yeah. Yes, it was. But I hope that somebody was able to tell Natasha Heath yesterday, like, I think we're good. I don't think we have to worry about that being
I hope
on a
so.
public docket because whether, and that's the other thing, these feminists, like, you should not want that.
Right.
Even if you think Blake Lively is telling the truth, why would you want someone's private birth video to be
Who's
shown?
not involved in this case? She just happens to be married to one of them. Like it's wildly offensive.
And do we want the law to, because the argument she's making is that birth is sexual. Do we want the law to adopt that? I don't.
Ew.
I don't like where we can go with that, you know?
No.
Conversations about motherhood. I mean, all of it. It just is, it's not a good lane for the law to take. And that was a really satisfying part of the order where he kind of goes through, this is not sexual harassment. I felt good about myself reading that because I was like, this is what I've been saying.
Right.
Like, you, the internet, are allowed to think whatever you want, but I'm a little bit gonna side eye you if you come to me and say somebody called me sexy and, you know, or I was acting out a scene with somebody that I had contracted to do. And can you believe it? He tried to kiss me. He tried to nuzzle up against my neck. Like, okay.
He did do a little note that sounded like, I feel like this came from him talking to his brother over New Year's or something, where it was like, directors do direct, but they also, like, you know, there has to be artistic license, which is what we had heard at the hearing, right? Like, he kept going back to, but in an artistic project, don't people have to have some, you know, way that they can be in the moment and change things? And I mean, he specifically said that Baldoni changing the script to add more sex stuff was not sexual harassment.
Right.
It's important because if it were, I don't know how that industry would respond.
Right. And some of that comes from the Lyle case too, right? Is it Lyle that was the Friends writing room?
Yeah.
Yeah. Where, you know, we need the ability to have these conversations and they might be offensive to some, but if they get us to the point where we're encouraging creativity in a creative space, that's important. That's
I just want to say, because I'm seeing more questions about it and we haven't talked about it in like an hour, I'm just looking at that scheduling order again from the magistrate. I don't know that anyone actually asked for this.
No,
do you think
It's
so?
the same language for plaintiff and defendant.
Exactly. Like, hey, now that the case is a totally different case, we need to talk again. Yeah.
Oh yeah. Yeah. It looks like it came from her. Yeah.
That may have been what was revealed during the settlement discussions, right? Something came up, and that this may have limited the world enough where she goes, hey, actually, based on some of your stuff, I mean, I don't know that she's caring that much about these individuals, but yeah, I don't think anybody asked for it. I think it was, hey, have your settlement positions changed based on what happened?
I mean, if she's been assigned, and this is, by the way, the magistrate we would have gotten if anyone had agreed to have a magistrate do stuff, I presume. You know, the magistrates kind of work in conjunction with the judges, the district judges. So if Lyman's like, hey, you know, I just entered this monster order, I think you might want to try to get them back together again. The judges all, and it's totally appropriate for a judge to say, hey, can you nudge them? I think maybe they need to talk again. In fact, the judge can force them to. I've been in cases where the judge is like, you will sit in a room and talk it out. And you know how I'll know? Because I'll be in the room. Like sometimes they will say, you're going to do this right now. So I think that's a good thing. I think that if that's what she's doing, I think that's smart to figure out where everybody is.
It's also possible that there were discussions that we're not privy to that said things like, come back to us after the order. Like maybe the parties felt so confident about how the order was going to go that they were like, we're not willing to budge until we get an order on that motion. And so the court's like, or the magistrate's like, all right, bet the order's out. So now what's your position? You know, let's pick this back up again. So
and there was,
go ahead.
Sorry. No, there was a
go
comment
ahead.
saying that Gottlieb ran to his favorite publication, People, triple hearsay. I'll never let it
Get a
die.
tattoo. I want you to get a tattoo that says triple hearsay.
Yes, please.
A tramp stamp.
Yeah.
But he said that was the heart of her case, is the sexual harassment. And so if something like that came up during settlements and now sexual harassment is gone, maybe there's a world in which, because if she was like, I am absolutely never in any world dropping the sexual harassment, pound sand, and now that that's gone, maybe there is a world in which the other things can be settled based on those conversations. So if Gottlieb's statement is true, which the last time he ran to People, it wasn't, right? But I just want to point that out as well, that if that was her position, sexual harassment is the hill I die on, then hey, has your position changed now?
Yeah. Does FIHA have a fees provision in it? If she were to win, can she get fees?
Yes, there are fees that she can get.
Are they reciprocal or just for her?
Just for her.
Okay.
I think so. I need to double check that if it's fee shifting or not. I don't want to misspeak.
Okay. Sorry, I didn't mean to put you on the spot.
It's okay.
Because, you know, the one thing about the retaliation claim for her is that is where most of her damages are, because she's claiming all of these ridiculous damages from Blake Brown and all this other kind of shit.
But so it does open up. Oh, go ahead.
No, I was done.
It does open up the world, though, of, well, we're going to tell this jury, and therefore the world, everything you were doing to smear us, right? And they may not want that out to the world, especially if their celebrity friends are involved and that burns bridges with their friends. You know, there are professional relationships involved between PR folks and their media sources. So I could see not wanting to try that case just because it is the last. I don't know.
Well,
I just could see not wanting to do it.
We don't know if there was we don't know exactly what their discussions are behind the scenes, but in California at least, I mean, I don't think there would have been a 998 type of thing. We have something that's like a 998 that's like a offer of judgment. Is that what it's called in federal court, where you are essentially saying like, I'm offering you this much money to make this case go away, and if you don't win over that, then it cuts off your fees, basically. This recently changed in California in 2019 with respect to FIHA, and it made it exponentially harder for employers to recoup their fees in Me Too type cases. So, I mean, at this point, it's really about mitigating loss for the employer, not obtaining the fees. A lot of people, this is kind of a related question, but a lot of questions that I've been getting is like, how do they essentially, how do they get something from Lively? How do they get money from Lively? How is she held accountable? And that's kind of off the table. And when I say it's off the table, I mean legally speaking. She might be held accountable in the eyes of public opinion, but there are no claims against Lively right now, or her husband, or her publicist. And all of the claims right now that are in play are against Wayfarer parties. And they are just defending them. So they're defending their reputation. And so a lot of people, I think that's why Van Zandt comes up a lot, is like, how do they get something out of it? And unless Wayfarer parties decides to do something with that, which we haven't seen yet, that would have to be an affirmative action outside of what they've already tried to do, which was bring the claims that they did, that the majority of which got dismissed. So, I understand the public's desire to see some accountability, but that's just not at play right now. It's not relevant until something changes.
And it might be in the Jones v. Abel case. Stay tuned, because we've got a
Yeah.
whole defamation claim against Stephanie Jones, and she
Right.
was a member of that subpoena, a party to. She's a member of the Van Zandt Society.
She's the leading member.
Probably.
If I had to guess, I would guess that in settlement discussions at this point, for Wayfarer, it is less about money than it is about transparency. Like, I would think, like, listen, we'd be willing to walk away from this and everybody just pay for their own lawyers and call it a day. But Blake, your deposition, your entire deposition is getting made public, because we don't want anybody to ever be able to say that there was something that the public didn't see. Like, if I were them, I think that's probably where my mind would more be, right? The information being out there is good for us. We're cool with that. We don't need money. We got plenty of money. I don't know whether Lively would go for that or not.
Yeah. I still think one of their biggest wins in settlement is non-disparagement. Don't ever talk about us ever again type stuff. I'll never say your name, you never say my name, and we walk away from this, because she's going to pound this drum for the rest of her life.
I think that's an excellent point, and that is something that makes settlement so powerful, is that is something you can't get in court. Even if she had, or they had, their best day in court ever, a jury cannot give you a non-disparagement agreement. You can only agree to that. So I'm with you that if it's like, you know what, let's just make sure that none of us ever have to talk about this shit ever again.
Yeah.
That's worth something, I think.
Yeah.
And Ryan too. Ryan's not allowed to talk about it either.
Yeah. I mean, you have to have Ryan as a signatory to that agreement. Otherwise it's a non-starter, but.
All right. So we went through, I think, most of it.
The last
but then
bits were dismissing Abel and letting Tag go forth, right? So for the conspiracy stuff, they said Jen Abel, no. Tag, yes. Is it Abel and Nathan?
And that's a really
getting all of the individual defendants dismissed was pretty huge.
That's a big deal for no other reason than that means that they can't go after your personal assets. Like, if there were to be some kind of judgment, and I'm not saying there will, but if there were, that means they can't, go garnish your bank accounts and take your house and all that. And I don't know what's in the name of Tag or It Ends With Us movie. Maybe they don't have very much. I mean, that's the other thing, and this is a way down the road conversation, but Blake Lively can get a $175 million judgment all she wants if Tag and Wayfarer don't have it. And Steve Sarowitz is not Wayfarer all by, like, there's corporate, organizations. That's why people do that. You can't get blood from a turnip.
Yeah.
Frank is snoring super loud. So if anybody hears that. Yes, I'm snorting, but also.
Also, and I know there's so many comments, and guys, we are trying our best to give you coherent analysis and our thoughts while battling our own congestion and reading everything. There's a lot. There's also super chats I see. Somebody says that Gottlieb said on People article from an hour or so ago that the sexual harassment was always the beating heart of Miss Lively's case. I didn't see that. I don't know what that's referring to. I don't know if you guys are aware of that. Is that
What would
old or is that new?
Yeah, that's older.
Yeah.
And that's what I was referring to earlier. Like if that really is the case and that came up in settlement, then there's a world that they settle. What would you advise if you were each party's lawyer? What do you expect to happen now? It's I can tell you what my ethic is as a lawyer, but at the end of the day, it's kind of hard because these aren't my clients and I don't know their goals. We can take guesses, right? Based on what we've seen, I think Wayfarer has a pretty good shot. So unless they can get a stellar settlement from Blake, like a walk away agreement, non-disparagement from both her, Ryan, and Leslie, like I say go to trial, honestly. And then, all the motions in limine and all that. If I'm Blake's lawyer, I'm saying you need to settle this. Walk away.
It's hard to answer this question because we're not privy to everything.
Yeah.
We can't, and I think it's hard for us to say how we would advise, and I don't know if it's right for us to do that, to be honest, because we are saying our hypothetical advisement based off of limited information.
Sure.
Like there's also impeachment evidence that we haven't seen that they're holding on to for trial that could be really juicy. So like it's hard to know whether or not like they have that gotcha moment that either side could have at trial. Based off of the record that we have, it feels to me like, yeah, if I was advising Wayfarer, I'd be like, it's probably a good idea to try this case, but I don't know if there's worse text messages out there that could really depict them in a worse light. And I don't know what there is on Lively's side, so it's hard to know. I can say that, like, generally speaking, it's in the interest of all parties not to go to trial because it's so expensive and so invasive and so tiring that it's better to sort of walk away with your head held high. But we're talking about a situation where people's reputations and professions are on the line, and I think it's just a really tough call, honestly.
Annie Jones asked, what is impeachment evidence? It's evidence to contradict somebody's testimony on the stand. So Blake Lively gets up there and says, I have never said X. And you go, are you sure about that? And then you bring in some external piece of evidence to contradict that testimony. A lot of the times it's a deposition. That's why you give a deposition, or that's why you take depositions, right? So you can say, do you remember this other under oath thing you said that contradicts this? And you read it out and you make a whole big show of it in front of the jury, and the jury goes, ooh, well, she's dishonest about that. What else is she dishonest about? Or what else is she not remembering correctly? Or,
I was just looking at my TikTok comments, and there's apparently something going around where someone is saying, oh, she can just refile the case in New Jersey. No. Limitations has passed. And there's rules, and you have to file all things about
res judicata.
Res judicata, yeah. Like, no. So if you see anybody saying she can refile, that is absolute horseshit. She cannot.
Which kind of goes back to the beginning where we addressed with prejudice, without prejudice. This is a decision on the merits, right? So with prejudice means that case can't be brought, similar to a decision on the merits. And when you have a decision on the merits, we have rules that say if you have the same parties under the same nexus of facts and a final decision on the merits, you don't get to run to another venue and try again.
Yeah, that's not
And
how
we
it
Well,
works.
and
want
someone
that.
just said, like, why didn't she file it there to begin with? That goes back to my thinking that like they didn't actually think that this was gonna get here. Because, they had all of this information before they filed their CRD complaint. But this all kind of got rushed together after the New York Times article dropped, and Wayfarer was like, whoa, wait a minute, what is this?
I think it's because independent contractors aren't covered in New Jersey. I looked it up this morning. They're covered in New York, but they're not covered in New Jersey. So I
Interesting.
think it's like, okay, let's go with California. Okay, someone just asked a question that is so good.
Ooh,
How can she sue for breach of the rider agreement when she is Blake Lively individually as the plaintiff and the rider agreement is with Blakel Inc.?
Blakel Inc.
Which raises that alter ego question that he dropped a footnote about.
Mm-hmm.
But I wonder if that will be excuse me. I wonder if that's, I'm trying to think how you would litigate that. I mean, she is Blakel.
She is Blakel.
But if she represents that she's Blakel, then that fucks up her tax situation. Then why have Blakel at all?
And
Yeah.
wouldn't that create proof in a future piercing the corporate veil claim? Not that that is guaranteed to happen, but it seems like evidence that you create for future liability down the road that you don't want to have.
Right.
Not that she couldn't create another LLC and whatever, but
And I think all of the arguments that all of us have looked at and made and thought of, and all of you have thought of over the past years on the merits about the rider are still in play. Like, did they sign it under duress? Right? We still don't know where the original 30-point list is because she couldn't produce it with the metadata on it from when it was actually written, which will be the example that I use from here on out about why just because something is attached to a complaint, you shouldn't believe that it's evidence, because it might not be. So they still have available to them all of those like factual arguments. I think what we're trying to figure out is there any legal way to say you don't even need to get that? Because once you get it in front of a jury's just deciding what happened and then matching it up to the instructions that they've been given. But that's a really good point. Like, how do you address that? Because who testifies on behalf of Blakel?
Herself.
right.
Did they do that? I wonder if they did a corporate rep deposition of Blakel Inc.
I don't remember seeing that.
I don't know.
I'm trying to make sure that we address all the questions.
I'm
Let me see.
looking at my TikTok questions.
I put some in a notes app. What evidence of the SH can be used at trial? We kind of covered that. I think that's a motion in limine. If not, that gets tailored down. And to Elle's point, if they agree that the protected activity is happened, there's a good chance then we don't get into the sexual harassment as much or at all, which that stipulation could do for them. That's an interesting, I like that.
The other thing too is, to the extent that sexual harassment evidence, talk me out of this, to the extent that sexual harassment information would come in, it would all have to come from her. I guess they could have Jenny Slate come in there and testify. But like,
See, that to me, I would say is prejudicial.
But for what purpose? Yeah, what purpose would they be
Well,
allowed to?
to say that she was reasonably making this complaint, right? Because we have to say that the protected activity is reasonable, don't we?
But to Nag's point, if we if we have to have evidence of that, wouldn't it just be that she made these various complaints? I mean, the judge has already basically said there was protected activity.
Right.
So I think
And that's why I think you say we're not going to fight you on the protected activity we can stipulate that it happened, and then we don't have to talk about what the protected activity was about, which
Right.
to me, you've got a strong, that gets the substantially more probative than prejudicial question, right? Like,
Yeah.
I think you say that's more prejudicial than it is probative, because it's not about whether or not we harassed her, it's about whether we retaliated. But if the jury thinks we sexually harassed her, even if, you know, if they agree, then they may find against us just because they think we're harassers. And so it's better for us to just stipulate to that, say, yes, the protected activity exists. It's already the rule of the case.
At the very least, you'd want a jury instruction that says to the jury, you may not consider whether you think there was sexual harassment, or like, that is not part of this. What matters is whether she had a good faith basis to blah, 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 blah. But that is very tough.
Yeah.
That
Because
is
on the other side, do you want the jury to hear some of the things she thought were sexual harassment? Because that kind of hurts her credibility, in my opinion.
I mean, that's one of the hardest things about employment cases too. Like, I'm sure that little girl attorney, you have experienced this, that a lot of times for plaintiffs in employment and all types of discrimination cases, 90% of the evidence is on the plaintiff themselves, because the claims are about what they experienced, what they felt, what they saw, how it felt to them. And so there is no way for her to get out of the fact that her view of things is going to be central to anything she tries to prove. So anything that undercuts her credibility, I imagine Wayfarer is going to want. Because in the end, it's going to be her story.
Yeah.
When I went through my investigation, I was like, just so you all know, I'm an avid journaler. So I have real-time impressions.
Contemporaneous notes. Exactly. The best advice is to tell people to journal.
A couple of people. Go ahead.
Yeah, go ahead. I was just going to make a last point on the testimony thing, is that somebody asked, is she even going to testify? I mean, absolutely, she has to testify. It's very, very weird for a plaintiff not to testify.
First one on the stand.
Yeah, and to tell her story. I mean, it's true that what is she going to say about the impact? I mean, I can imagine with respect to retaliation, she says my entire life is ruined because of what they did. And like, while they're not going to go into emotional distress, she's going to say, like, I have no job prospects, I have no hope, I have no nothing, because my online reputation was destroyed by these people. That's what she's likely to say. So I can't imagine a world where she wouldn't testify about that. Now, she's not going to have a whole lot to say about the contract thing. You know, she might say, like, yeah, I worked with my lawyers because I really wanted to protect myself, because I thought that they were going to go do this, and so I wanted to protect myself. She could say something like that. But that opens her up to all the credibility challenges, which I'm sure Wayfarer will have.
I guess too, by making that 17-point document the center of her case, that necessarily means that Wayfarer has to be allowed to say, and all these things, when you brought them up and said, don't do that anymore, we stopped doing them, right? Which I think boosts their credibility again, right? Like, I don't know.
Yeah.
I don't think there's a way for her to frame it. I worry about it becoming a battle of the experts, is what I would worry about. That, you know, they're going to talk about what they felt, and she's going to talk about what she experienced, and Friedman's going to say, you can't know what's in somebody's mind, and blah, 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 blah. And then they're going to have experts get up there, and one expert's going to say, this looks like bot activity. And one expert's going to get up there and say, no, it doesn't. And that's just the shittiest type of trial ever, is when it's a battle of the experts. It's totally unpredictable. That's what I would be concerned about, is, are we just going to have to get up there and battle about how you identify bot activity, which frankly, to me, from the little I've read in this case, seems practically impossible to prove.
Oh yeah.
Like,
yeah.
two experts of both of very high stature, super impressive credentials on different sides saw totally different things.
Mm-hmm.
You really want
Yeah.
a jury wading through all that shit? I don't know.
Yeah.
Well, and I don't think we have the actual data to show it. Just we're looking at it from the outside data, but not the actual. I don't think they ever got like, okay, show us everybody who liked this video, and then we're going to look at all those profiles. I don't think we went that granular. So we don't actually know what it was. I mean, I don't know. I think that's like you said, that's a battle of the experts are tough cases. A lot of environmental laws like that, and it gets explaining these tough concepts to a jury, first of all, is incredibly hard. And then when you have two people explaining the same concept and saying entirely different things, the jury confusion is through the roof. And then you have an attorney saying, well, you heard our expert, and they're like, did we?
It's so boring.
Yeah.
I tried to read that, whatever one of those expert reports was that they had on bots, and I was so bored. I was like, I'm going to fall
Yeah.
asleep.
Yeah. I stopped reading one of them because I was like, I don't care.
I'd be interested to hear what Sarah Yarn and Order has to say about it, because
yeah, she's probably got those memorized.
She probably could like give us a tutorial on this, but like
she could.
This is the kind of issue too where everybody's going to bring some personal experience, whether they intend to or not, right? Like, well, I liked a video once. Does that mean they're implying that I don't mean what that I don't, my comments are not really my comments, or the opposite? My cousin Billy runs a bot farm and I know this stuff, whatever. Like, social media activity, authentic and inauthentic, is part of pretty much, unless they go get a bunch of people from Amish country or something, is part of everybody's life.
Yeah.
And so everyone's going to have their preconceived notions. And my guess is that most people would land in the middle. Like, yeah, it's possible, but show me one comment or one post that goes from A to Z. Show it. Jed Wallace posts it and it gets boosted by this account that's owned by Melissa. Like, without showing that, I think it'd be really hard to prove.
Yeah.
Yeah.
Well, and then Ashley Brianna Eve did a whole series where she was like, there's a certain amount of bots just out there on the internet anyway, right? So she was like, 20 to 30% of your engagement anyway on any sort of viral topic already is going to be bots. So if Blake is a viral topic, you have these bots just out there in the world anyway. So how do you prove, like, to your point, how do you prove those bots weren't directed by Jed Wallace? I don't know.
Yeah,
that's tough.
Everything that everyone says and likes on social media, their deepest held belief. I mean, I have liked stuff on social media and then later been like, I shouldn't have liked that. I didn't really like that.
Well, it's also, it doesn't always mean you like it. You're just acknowledging it. I get
I know her.
Like, oh, she liked this comment, therefore she is, whatever. It's usually people
I feel
on
like
Reddit.
that's a generational difference too. To like something now means you like every single aspect of the comment, as opposed to like, I feel like our generation was, we liked it to acknowledge we saw it.
Acknowledge I saw it. Yeah.
And
And it's
like,
super
hey,
inconsistent. Like,
yeah.
Or like I'll read comments and I see the top 25 and then I won't see the rest. So I've acknowledged 25 of them. Are people like, oh, she liked this comment, but she didn't like this other comment. It's like, you can't read into that. If I had to testify about my behavior, it would be like, I don't know. Sometimes I just press it because I've seen it. Other times I actually like it, or I think it's funny, or I don't think. I mean, there's no consistency. So you can't even rely on that. I want to point out, Attorney Starr said, here, maybe I can show it. I think this is totally true. That people don't want to think that they are susceptible to bots, and I think that's so true. And so if you're telling a jury, like, you're basically telling them you are susceptible to this, and like you don't know what you like and you don't know what your feelings are because you've been manipulated to think that way. And that's especially if you're talking about something that they have their own opinion about, they're going to be like really resistant to thinking and feeling that way. Hey guys,
Yeah.
I'm seeing that we're like at the 2-hour mark. How are you feeling?
One more thing I've seen come up a lot is how can the contract writer agreement be a contract if the contract itself wasn't signed? And the judge goes into it in much more detail, but the thing I want to point out is the judge says there's language that says the contract writer agreement shall govern if there's any sort of inconsistency between the two. That was a big point the judge relied on. The judge we talked about the consideration a little bit, but the judge goes through that in quite a few pages. But he talks about, the contract writer is enforceable because of the language within the contract writer agreement. So a little confusing because I was pretty sure he was going to kick it out because the contract itself wasn't enforceable, but he looked at the language and said, no, I think it is.
Mm-hmm.
I think this meets the elements of a contract, and this contract says, in the event of any dispute between the two, rely on me. So he did.
So he did. Yeah.
So he did.
And I see where he went with that. I was like, okay. I hadn't really seen it that way. I'm just looking at like the notes that I made. I wonder if the Lively people are going to turn on Gottlieb.
Yeah,
Because,
the way that people turn on Friedman.
right?
Sue your lawyers, Blake. Come on, give me more.
You're like, oh, why did
Do
he
it.
sue in the
Come
wrong
on.
place? Blah, 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 blah,
Yeah. Will they show the Blake Lively spectacular interview performances to the jury at trial? It is the one with Shirsty and the other one saying location share, etc. I mean, maybe that could be a good motion in limine as well. Hey, let's leave these out and just sort of agree that she was flubbing or get some testimony that she was not doing well promoting this movie, and talk about how that's a potential that you hired crisis PR. But I'd be moving to exclude that if I were Blake.
She'd probably want to exclude that, and they're probably going to say, we want to call her as a witness. We want her to testify about why she put that video up. I would, if I didn't pay her to do that, I would call her.
Yeah.
I mean, I cannot imagine. Well, and she gets to go first, I guess, because it's her claim. But like once the jury has seen those two, Britt, that you just mentioned, once they've seen the little bump video and the location sharing video, how in the world are you going to turn them around to this happened because these guys were mad? Like that would be really hard to undo.
Yeah.
I mean, there's all these documents and there's things people are saying, but like video burns in the brain like nothing else.
Yeah.
And, when you've got a visual, it's on a piece of paper that Melissa Nathan said, blah, blah, blah. But.
And if you can get an expert to get up there and say, when something goes viral on the internet, content creators, because it's a whole industry and people are making money off this and people are trying to go viral, content creators are looking for their own take on it. Right. And they're going to go looking for anything. Is it the right word? Did a whole video on that as well, talking about Chapo Rome, but so people are going to start digging into you. And now you've got people talking about your wedding and your clothing lines and right. And so I think if you can get someone up there to say, once something like this goes viral, the internet is just thirsty to pile on. And they needed crisis PR because this pile on was happening. Blake is doing her own smear campaign. They were underwater so fast, they were above their heads. They needed help.
Yeah, and you're right. Like this is really helping me hone in on the Wayfarer team, they have their defense of, no, these things don't mean what they say they mean. But their main defense is there are plenty of reasons to hate her that have nothing to do with us. That's their defense, which means that everything they can think of that is a reason why people don't like her is fair game.
Right.
It would just be a, one after the, she shouldn't have been cast, the plantation wedding, that like,
I would,
I mean,
if I was
Gawker
Wayfarer,
CC
I would be bringing all the content creators that talk about this case early on and had them say why they started talking about the case. Like, where did they, and have them walk through. No, it wasn't because I got 50 likes on my video that I continued making them. I just dug more into it.
Yeah.
Or no, it wasn't because somebody called me to make this. I just thought I felt more passionate about it. Like I think that's what I would do, is like really lay out for the jury, like all these people that you're claiming talked negatively about Lively because they were manipulated to, were doing it on their own accord, and have the jury decide what they would do if they were in that situation.
Or like, I think, Britt, didn't you and I talk about this like a million years ago? Find one person just through comments or something, just like a regular citizen that's willing to go and testify, I'm a domestic violence survivor, and the way that she that movie was so offensive and triggering to me. Now, yes, you'd have to get some instruction that she doesn't speak for everybody, but I don't think it fucking matters.
No.
If you get somebody up there to say that was so offensive to me, the way that she marketed this movie, then who cares what all the stupid charts and statistics say?
Yeah.
Although they're gonna challenge that, because they're gonna be like, no, like, we don't want to hear that. We didn't get to depose them or whatever.
Well, here's my comment on this on the baby bump video, right? Or here's my comment on the location share video. And I reposted this video. I posted it to my Instagram. I was, boosting the algorithm's chance of other people seeing it because I was engaging with it, because I found it so offensive.
That's the thing is, I mean, the closing argument writes itself, right? Like, how can you ever really know what's in somebody's mind when they press that button? How can you ever really know what's in somebody's mind? Yeah, maybe they told Sage Steele what to say. That doesn't mean that the 2 million other people who are upset on Reddit about the plantation wedding aren't real people.
Also, she said, as far as I know, she made one video. I don't even think I've seen that video.
I haven't.
Because every time I see her name, I'm like, who is this again? Like, how is she relevant to this case again? I don't even know what she looks like. So, like, she's like a non-issue to me, but they keep hinging on the fact that, Brian Friedman apparently, and that was the first time I saw in the order that he had some text that said, she'll make this video or what have you. That's probably why they were so up in arms about her. But like, she's irrelevant in the content creator world, as far as I'm concerned. We've never seen her talk. So what about all these other people that have been making content, right?
Yeah. That'd be
I'm admittedly losing steam. How are you guys doing?
Yeah. It's happening. It's happening. All right, you're supposed to be the one who has your shit together.
Yeah.
Way to go.
I'm being harassed by a crazy person and I'm losing sleep over it, so that's a good time.
I'm so sorry.
We should all retreat and get some rest. But we should say thank you to there. At some point, I think I saw like 3,400 people viewing us, which is awesome. Thank you guys for joining us on a Friday afternoon. This will get automatically reposted on YouTube on all of our accounts, and it'll be available immediately for replay. So in case you missed any of it, there is going to be a full long podcast length video for you to watch. But yeah, we'll keep thinking about these. We can do another live as soon as those motions eliminate come out. So we're not going anywhere. There's still a lot of case left, I think.
I'm relying on Sarah to keep track of all those deadlines because she always does.
Yeah, she
Oh yeah,
keeps me in line
she's
too,
great.
so
She's
she keeps
amazing.
my deadlines in line.
Yeah.
Yeah, we've
If we
got
ever
motion to
form a
eliminate
firm, we're hiring her.
Oh, well.
100%. I've a few times said I would love to get her through paralegal school so I could pull her over to Arizona and hire her. We've talked
Oh
about
my
it.
God, she'd be fantastic. Are you kidding? She'd be
Yeah.
amazing.
She
Mhm.
could almost like paralegal clerk, even though
Yeah.
she doesn't have the. But yeah, she's crazy smart.
The one thing we didn't
Mhm.
answer, I just want to say before we finish is why do people come to my house when I'm on a live? Okay. Frank, why are you not barking at that guy? You bark at everything else, but he's fast asleep. A bunch of people asked about Jones. And like this doesn't technically change anything for Jones because she has a totally separate case and her trial has been put off.
Yeah.
But if there is a motion in limine about Van Zandt, that puts Jones right in the middle of it.
Mhm.
Because I think, wouldn't Lively need Jones to testify? Maybe. She might need Jones to authenticate some of those documents. So I don't know. I haven't really thought too deeply about where she is right now, but I don't think she's out of the danger zone, even in the main case, right?
Yeah, I don't think
Yeah.
so. I think it's possible she gets called.
And there's so much crossover between the two, right? I mean, even Blake isn't out of. Blake's going to come and testify for the Jones case, and Taylor could be testifying for the Jones case, right? So there's still so much more case in the other case.
Oh, can we do one more thing? Because I'm sorry, I meant to do this at the beginning because I need all three of our brains because I can't figure it out on my own. Okay, so the summary judgments are final orders, and so they are appealable. But based on the ruling that we got earlier on the Wayfarer side, would she need to wait until the whole case was over to appeal those? I think.
That has always been my understanding, is that you have to wait until the entire case is done,
Mhm.
right?
I think so. I think so. I've just been thinking about it all night, and it's like, I mean, technically, I mean, if you were her, you'd want to make sure you didn't miss the window because it's only 30 days. But
I think the entire case has to be done
okay.
for her. It doesn't seem to me like it's interlocutory. There's definitely case law on this. You just have to
It's
look it up.
final.
But
I mean, it's a
but it's
final
it's
decision. Like
final.
those claims are out. She'd be an idiot to to appeal any of this stuff.
I wouldn't advise it. I mean, it's just going to drag it. Although it's always a leverage point for litigants. Like, oh well, I'll drop my appeal if you settle.
I
So,
mean, and that's good leverage. Hey, do you really want to get all through trial? And I'm gonna appeal this. So we go to
Yeah.
trial. I appeal it. The appellate court says something is wrong. We're doing another trial. Do you want to do that?
Yeah.
I mean, does she want to do that?
I do, but
You do. You definitely do. But
keep
people
it going till the end of time.
they get so tired. Everyone's like, "Oh, can he sue her?" Like he probably can't, but you honestly like you just want it to end.
Yeah.
You get so because if you bring any claim, you are getting deposed and you are getting people in your documents, and that will wear you out. That'll take like years off your life, honestly.
Mm-hmm.
Yeah. Appeals are tough. And then to come back and do some of it over again is also tough.
Yeah.
Yeah. No, we're talking about multiple years being added to this, which I can't imagine either side wants to endure because their livelihoods are on the line here. So,
Yeah.
Chelsea, a lot's going to happen in the next week.
I'll look up the specific rule on that, but I feel certain, and I can't remember the language, that the case has to be done to have an appeal as a matter of
I
right,
think so.
which is why Wayfarer hasn't had the right of appeal, although a little different because it was dismissed partially without prejudice, partially with, but
Yeah, I
Yeah.
think you're right. I'm pretty sure. But like tip as the internet does, there's some yahoo who's like, she can appeal right now. It's like, ugh. Just because you have Google doesn't mean you understand how this stuff works. Yeah, let's confirm it, but I'm with you. I'm like 95% certain that that's the situation.
Yeah.
But all right, we're gonna go nap.
Yes,
All
we're
of
gonna go
us.
rest.
Not together. We're in 3 different
Thank you all. It was really
Thank you,
good to talk.
guys.
It
Thank
was
you
fun
to
hanging
everyone,
out,
our
ladies.
viewers. It was fun to see everyone. Take care. Bye.
Bye.
Bye.